My lord, may I be permitted to mention, my lord, for application, my lord, inclusion in the list, my lord.
New application.
New, my lord,
It's not hard earlier.
not hard earlier, my lord. I'm grateful, my lord.
May I have your lordship's kind leave to mention for correction, your lordship?
What correction?
The correction is that the appellant's name of the advocate who appeared for the appellants came wrong in the order.
Give it to be mentioned. Yes.
My lord, may I have my lord's leave to mention, my lord, for upgradation, item 23 of the combined list, my lord. My lord, this matter was heard.
Called on.
Yes, called on, my lord, on last Friday. My lord, last Friday, my lord had indicated that to remind, my lord, to seek upgradation, my lord, because, my lord, there's a contempt proceeding that the writ petitioners are proceeding with. My lord, it's
you
a stay
mentioning upon
application.
notice?
Yes, my lord. I'm mentioning upon notice, my lord, stay application affidavit is complete. There was a direction of the Honorable Chief Justice, my lord, the coordinate bench, my lord, that the prayer for stay will be considered after exchange of affidavits. My lord, it's ready for, my lord, only for my prayer of stay. The contempt proceeding is, my lord, pending before the learned single judge. Deeply obliged.
My lord, I am praying leave to file appeal without certified copy.
When was the order passed?
On 24th June. 24th June. My lord, I made application, my lord, till date, my certified copy.
When did you apply?
My lord, on next date, my 25th, my lord. My lord, I have annexed.
What is the urgency, sir?
Urgency, I am going to be out statement from my dwelling house, my lord.
Leave grant.
Yes. Lordship, may I be permitted to mention this matter for inclusion in the list, Lordship? This matter is pending since 2017, Lordship. The stay application has been pending, Lordship. I am mentioning upon notice, Lordship.
When was it last heard?
In 2017, Lordship.
So what were you doing since then? 2017, oh, you were also sleeping.
Lordship,
Hand over the sleep. The Pele combined list.
Lordship, kindly fix a day, Lordship, kindly. Lordship, kindly, Lordship, because the sufferer are the...
Lordship, 5 years you kept quiet and you will not allow it to be listed also in the combined list. Yes.
Lordship, the sufferer are the residents of the municipal area, Lordship.
আমাদের 2023 থেকে appeal from order related risk. Oh, sir, we don't have determination. 2017 appeal. Go to the other court. We have determination from 2023 onwards. Yes.
Lordship, may have your kind leave to mention appeal, your lordship. Appeal for the respondent. I've mentioned it on Tuesday, your lordship, but directed me to
respondent. You are
respondent, your lordship. The lordship, the problem here is, lordship, the appellant here, Aditya Birla Finance, they are I'm the borrower, your lordship. Now I am the borrower here, lordship. They have filed an appeal. They have got a stay there, and thereafter there was direction passed on them to amend the cost title because they have appeared and submitted that the said debt has been sent to the asset reconstruction company.
They have not got any stay.
They have gotten a stay. They're enjoying a stay, your lordship. There was direction on them to amend the cost title and continue with the appeal, but they have never followed.
When was that order passed?
Lordship, the order was passed on 19th of February 2025, your lordship.
19th
February 2025. And
have you filed your opposition?
I have filed my opposition in the appeal, your lordship. They have taken time to file the rejoinder. They have not yet come with the rejoinder yet. And on 6th of May, your lordship, the matter appeared here. They have said that they seek some time, but they have never taken any step, your lordship.
Your lordship, I appear for the petitioner, your lordship. We are in the process of filing the substitution application, your lordship. May I hand over?
Substitution application?
Your lordship.
He's saying amendment?
Your lordship, that is their submission, your lordship. And same has been
filed the substitution.
Your lordship, the thing is it is being notarized from Delhi, your lordship. The officer who is going to sign the
your lordship, 5 months.
He's from Delhi, your lordship. I have a email communication from the client, your lordship.
When did he expire? When did the person expire?
Your lordship, the thing is the company is being changed, your lordship. There is an acquisition of Aditya Birla.
Change of name of a company.
Yes, your lordship. It is
8 months.
Your lordship, it is being done. Your lordship, it will be done by this week, your lordship. Kindly keeps it in any day next week, your lordship. I have no problem, your lordship.
Lordship, kindly.
You have to give the number of the application. Unless you give that, how it will be listed?
Your Lordship, we are in the process of getting it done. Your Lordship, I have
This
emailed.
process is continuing for so much long time, na? Then we will vacate the interim order if you are not interested.
Your Lordship, kindly gives me one opportunity, Your Lordship.
Your Lordship, they appeared on the last occasion and they have said the same thing, Your Lordship.
Then we will list it. We will vacate the interim order when
Your Lordship would kindly fix it any day next week, Your Lordship. I'm suffering. They have my property. They can sell it
we
off
have
any day.
heard.
So-
There is no necessity for repeating a single thing 100
Apologies,
times.
Your Lordship.
Yes, when will you file it? Tell us.
Your Lordship, by tomorrow or by Monday, Your Lordship. That is
Give a copy to him.
Your Lordship.
Next week. Yes.
Great.
May I be permitted to mention one matter? Matter Mat 806 of 2025. Matter was lastly heard on 19/6/2025. On that day, the other side has taken a time for 2 weeks. The matter has not been listed since from then.
देखे ना होगा. Yes, madam.
Sir, Monday I had mentioned for my case. Sorry. My lord, I have one mentioning for inclusion in the matter. Actually, the applicant
Inclusion of what? Application.
application
Have
right.
you mentioned, given notice?
This is for original side.
Original side. Don't see your mobile, madam. Where is your mentioning slip? Have you
This is
given?
this
Have
is
you
yes.
given copy to your other side?
Yes,
Have you
yes.
given notice?
No, this is not a notice. This is for the
Please give a
inclusion.
notice. Please give a notice and come back on Monday.
Okay, my lord. Thank you so much.
Your Lordship, I, Piyush Bandyopadhyay, petitioner in person, file MAD 932 of 2025, CAN 1 of 2025, CAN 2 of 2025. Date of listing was 9 July, yesterday, Your Lordship. The petitioner is praying of above contempt appeal petition is praying urgent listing and hearing due to anarchy in the state of West Bengal. PF gratuity pension settled without last pay certificate.
Wait. Whose appeal is it?
I appeal.
You are the appellant. You are the appellant.
I am.
Appearing in person.
I
You
am
don't
appearing.
have advocate.
No, I just, I have had no money, Your Lordship.
Now, who is your other side?
Kishore Karmakar, alleged contemner.
So, did it appear earlier?
I already served notice.
Matter was in the list.
No, I actually, the list was fixed on 9 July, as per proposed date was. Proposed date at the time of filing.
Was it heard earlier?
No.
Give
first-
this.
Sir, on Monday I had mentioned for my case, but still the
So
case
you
is
don't
not.
have an advocate?
Sir, actually, I want to move my case on my own. Sir, I would be able to.
For that you have to give no objection to the advocate.
Sir, I've never hired any lawyer. Who would I give the no objection certificate? Since the beginning.
Just now you said that I do not want to continue with the advocate.
No, sir. Monday I had mentioned for my case, but still the case is not included in the cause list, sir. And sir, in National Commission, the evidence stage is already over. So I'm already late, sir. That is the reason I'm requesting this court. If the case can be taken into consideration on.
Did you file it? Did it appear earlier?
No, sir. On 26th of June, I have filed the case. The date which was given in the notice was 4th of July, sir. On Monday also I had mentioned.
Not the system. Did you mention on Monday upon notice to your other side?
Already, sir. Everything is done.
Give your slip.
Sir, all the opposite parties, sir, 7 opposite parties are there.
Good, madam. Hand over the slip. Matter will appear. Keep a watch on the list.
Sir, Monday I did everything. Monday I submitted the mentioning slip.
It was file has been called for, requisition has been sent. Unless it comes from the department, it cannot be listed. So please give your slip. He will consider. Yes, call the list.
Item number 1.
I am finding section against the report.
কাটি দেখে দিয়ে দাও নয়।
I proceed in the matter. I should draw to my lord's kind attention that my lord, on the last occasion when my lord's passed an order, this order was passed on 22nd of May 2025. Your lordship passed an order.
Exception copy has been given to
Yes,
you?
yes. Now your lordship passed an order on 22nd May 2025.
Yes. Yes.
Now, my lord, one thing I should indicate to my lords, my lord, this I come to learn from my client, that my lord, there is no mention of either LR plot or RS plot in the order which my lords had indicated. Your lordship indicated plot number 323, 324. But my lord, since there is no mention,
320, 322 and 323.
right, I'm grateful to my lords. Now, my lord, your lordship may kindly consider that my client had gone there and had given a representation, but my lord, she was told that unless there is an indication of LR plot or RS plot, it is difficult for the authorities to ascertain as to where the house is situated.
That is not their case in the report.
No, I say, my lord, I only indicate to my lords.
You should have come immediately thereafter and told us if anything was lacking.
My lord,
if there was, you are now saying that it is plot number given, LR plot not given.
yes.
So,
My lord, your lordship may
plot
kindly
number-
consider page 3 of my lord's page 3 of my lord's order dated my lord 22nd May 2025.
So that 323 itself is the LR plot.
My lord,
LR plot is
my lord,
323.
the instructions which I got, I'm just
So
indicating.
what is it? This is a civil dispute.
No, I know that what your lordship is indicating. Your lordship is
We are not indicating, the report is indicating.
no. I say only this thing because your lordship wanted.
It is 323, LR plot number is 323. So you cannot proceed on that ground. Tell us
I
what
am
merit,
just-
what do you have?
I have only I have to say only this thing, that so far as my deed is concerned, the registered sale deed, that is the sheet anchor of the case. Now, so far this particular deed is concerned, your lordship will be pleased to find
Page 41.
page 54. Yes, not 44, 54.
Yes, LR plot is 323.
LR plot 320. Kindly see land details. LR plot 320. LR 320. LR 323. 322, 323. And structure details is also LR L6. Kindly see, this has been indicated in page 54.
So that is LR.
Therefore, I say now what happens, because your lordship wanted my client as well as my lord the other side, my lord, to be present and thereafter to make an inspection. Now what has happened is that I have given in my exception to the report only, my lord, this thing I can indicate to my lords, thereafter whatever, because the
Exception.
the exception, yes. My lord, I do not blame the state now. I say, my lord, what I say, that my ill luck, that I purchased a plot having a land details, but my lord, the authorities, they rightly, my lord, showed that either it has to be LR or it has to be RS. Now, my lord, the client is totally confused that I have purchased a land with a house, and now if you say where it is, then where I go? This is the only thing where I kindly, my lord,
So what is it? Why didn't she, your case is
really.
you have been forcibly dispossessed.
Yes, yes.
That is your case.
Yes, I have lodged a complaint before the Yes,
As regards threat perception, we understand
yes, yes, yes,
that you
yes,
are she is an aged lady, threat perception, and to that effect, court has granted protection.
I'm grateful.
Now, so far as this indication, what plot is that, what land is that, what building is that, we still on the basis of your prayer made, we directed them to conduct an inquiry.
Yes.
They have also called the BLRO. They have made a statement that in 320 there is a
Milord, the
Kaccha
BLRO, Milord, help me.
Mhm.
BLRO, I should submit this thing, Milord, as an
Show us
officer.
then. Show us.
As an
Argue
officer
your
of the
case.
Milord, just one thing, Milord. Just a second, Milord. BLRO কাছে তো আপনি এটা তো এই চিঠিটা তো করেছেন তো Milord, kindly see the letter, Milord, of the report. Inspection কবে হয়েছে?
30th of June.
Milord, the inspection was held on 30th of June. And kindly see the assistant director BLLRO, he gives, I'm sorry, Milord.
Report. Yes.
Milord, your lordship may kindly, Milord, see the documents in page 15, 16, 17 of their report. I mean, now in a totally helpless condition. I cannot, because uh, they are saying that a house, their contention is that the house is in one portion, very good one portion, therefore the land must be free. Now the particular, now today the BLRO says that immediately you come to the office of the BLRO and take the particular necessary, you take necessary steps, otherwise you will be getting nothing in spite of purchasing it. But the land details of the registered deed Please,
your exception.
yes, I'm grateful. That's what I wanted. I'm grateful. Miller, from page 3.
Yes.
Not exception, the exception. Yes, my exception. Sorry, I stand wrong, Miller. It starts at page 3, para 4. It would be found from the registered sale deed, and more particularly from page 54. Has my lord got it, Miller? That the appellant purchased the RS plot number 280, 282, 283, comprising of 12 decimals of land, along with one-storied building comprising of 660 square feet, as would be found from page 54. The corresponding land record in LR record of right is LR plot number 320, corresponding to RS plot number 280, LR plot number 322, corresponding to RS plot number 282, and LR plot number 323, corresponding to RS plot number 283. It is stated that the land purchased by the appellant clearly indicates the land details, as would be evident from page 54 of the registered sale deed. There is LR 324 plot number in LR map, but there is no corresponding RS plot in respect of LR 324, and such fact would be evident from the plot searching report from the Land and Land Reforms and Refugee Relief and Rehabilitation Department, as well as from a copy of the RTI issued by the State Public Information Officer and Assistant Director of Block Land and Land Reforms Officer Korondigi, in terms of a letter dated 11/6/2025. Accordingly, there is no dispute about the fact that no data is found available recorded against LR plot number 324 of Mouja Chownagar, jail number 52, police station Korondigi, district Uttar Dinajpur, and such fact would be evident from a copy of the reply dated 11/6/2025 issued by the State Public Information Officer and Assistant Director of Block Land and Land Reforms Officer Korondigi, and a copy of the search of LR plot number 324, along with a request for submission of information in respect of LR plot number 324, and also information as to corresponding RS plot against LR plot number 324. And the corresponding, Miller, the RTI which was given, that is at page 14.
P24 is not in the picture.
No, not I say, Miller, this what has happened, I am just disclosing to my lord.
P24 you have not purchased. You have
320,
purchased 320, 322 and 323.
Yes.
So this has no relevance.
This has no relevance, but this has been shown. Therefore, Miller, I just bring.
Can we do that?
No, I know that, Miller. I say I am in a very, I am just, I can only humbly pray before the court, but I have nothing more to add. I can only do one thing. I can make a representation before the BLLRO or the DLLRO, whichever, and they
will not serve you.
Yeah, I know that, Miller. That's the reason I was telling my client.
You have to specifically give your sale deed. This is my sale deed.
That's right.
That is there. Sale deed is there.
Yes.
And you have to say, I have been dispossessed or I am still in possession. Then if any order is passed by the civil forum for non-compliance of that, you come back to us. But how in this dispute I can say?
No, I am only praying.
I am only residing in the, because you said that the lady is residing with her daughter elsewhere.
At present, Miller,
present.
just 1 second. আপনি এখন আপনার মা কোথায় থাকেন, মানে আপনার সঙ্গে না ও বাড়িতে, মানে যেখানে কিনেছেন সেখানে
না, সেখানে নয়, আমার
তার
মানে
পাশে।
আমাদের, হ্যাঁ।
Miller, on instructions I submit that they have another land besides the particular purchase plot. In that particular plot, Miller, they are now residing.
Which is that plot?
ওটা কত plot?
আমার বাবার বাড়ি,
ওটা
আমার
আপনার
বাবার বাড়ি।
That is adjacent to this?
Yes, adjacent.
So then there is no problem, Mr. Bhattacharjee. She has to go and agitate this before the civil forum. There is no other option available. Or you suggest, we wanted to help you out so that the
Yes,
problem
Lordship
can
Miller,
That is
did
why
what,
though
what
there
I
was an
am,
earlier report.
what I am entitled to get, your lordship has gone much further than that.
No,
There I cannot add a single
Mr.
word.
Sen, Mr. Sen,
Hey, Dada, আপনাকে just-
what is your case?
My lord,
Civil dispute.
no, apart from that, so far this, my lord, the objection raised, my lord, lordship, kindly come to my lord, page number 5 of my report filed on last occasion. Just page number 5. It is not a, my lord, it was a letter, page number 5 of my report. It was a letter from the IC Korondigi to the appellant before your lordship. My lord, that after my lord's order,
They have visited
I'm
conduct.
coming to that. My lord, it was mentioned therein that in the middle portion, you are requested to be present at the premises of Chounagara, that should be Chounagara Mouja, having plot number 323, 320, 322. Now, no objection, RS plot, LR plot, where shall I go?
No, this is LR plot.
This is LR plot. Always plot number means
That
LR
he
plot
has said in
normally.
his paragraph 15, Roman 14,
Yes,
that the RS and LR number of the plots are as follows.
yes.
Yes.
So LR plot is 320, 320, 321, 22.
Whatever be the corresponding RS plot. No dispute. I think, my lord, myopathy, and for all the time, there is no dispute that this is a LR plot and that LR plot matching with their claim of 323, 320. Though it's a dispute between two private parties, but the thing is this, that so far the records that is here, it is evident. And the sketch map is there also. My lord, in my report, page number 18, the revenue inspector, BLRO, there is a sketch map. No objection to this sketch map. It is
No,
basically
how
sketch map.
can he take objection? He is before us, na?
No, so far this sketch map. No, this is wrong. Page number 18 to my report filed before your lordship.
On the date of the inspection, she lodged a complaint.
On the date of the inspection, lodged a
Page
complaint.
18 of his
I
exception.
am not vehemently opposing, but what I trying to tell before your lordship is this. Because after all, this is a private dispute. And practically speaking, my lord, this type of dispute can be lodged into, my lord, after going through BLRO, then to the tribunal.
Say I am before my lords. I have nothing more to say.
No, I
What-
can. We
What
can.
I can say, my lord, I come with a problem in the court that I have been dispossessed, but now I find a different problem has, my lord, come up.
What difference?
The different problem is with regard to the number of the plots. Kindly see, my lord, the magnitude of the problem. I come saying that I have been dispossessed.
Mr. Bhattacharya, we don't understand this. Plot number was mentioned in the order. You could have come and tell. Now you are saying, since you have said plot number, there is no proper ID.
No, I say, Miller, kindly see, Miller, what has happened. I
Yes.
cannot say anything more.
You have purchased LR plot number 320, 322 and 320.
Yes, but
Inspection.
there is also RS. Kindly see
That is
Forget
corresponding.
about the RS. RS is the corresponding number LR.
of LR. Yes, yes,
That
yes.
is your case.
That is in the land details of the registered deed of conveyance.
So
Yes.
today, if you say that there has been no proper identification of the plot, that issue can we go into that, Mr. Bhattacharya? My brother was saying that the problem with Mr. Bhattacharya is as regards identification.
Identification. I'm grateful to my lord.
So
I am
identification.
grateful to my lord.
You tell us what order you want from us. Identification, you will not go and identify.
Eh,
Now BLRO's representative was there. Prima facie, why should we disbelieve that?
No, I am also not saying that the
No, you are saying
DLLR.
identification is wrong.
I'm grateful to my lords, my lord. Kindly consider. I say I can appeal to my lords, but I have nothing more to say. I have nothing more to say. I cannot make a statement, my lord, which and also see the last page. Why the BLR also told us.
BLROর কাছে তো পড়াশোনা হয়ে যায়।
Mr. Justice, my lord, Mr. Justice Zitopoto Mittomilo was addressing, not addressing, but my lord was making, my lord was passing a view that my lord kindly say this exactly the page 23 of my exception.
Exception. এটা
Yeah. In which portion which I purchase, where is the house, entire thing now Miller takes a new color.
No, this is a subsequent representation.
এটা ওরা বলছে।
By the BLRO?
No, not
This representation is, my lord, carries the date of 30th May 2025.
on the date of inspection.
On the date of inspection,
On the
after,
date of inspection.
that means during pendency of the, after passing of my lord's order.
Yes.
And
yes.
here, my lord, some new, my lord, the grievances are there with regard to also quantum of land in the area. These are all mentioned there. It's a press grievances. I cannot stand in the way with regard to the consideration of this. The state cannot say. I can only say if the order passed to consider this by the PLRO, then only, and then their grievance can be looked into by the tribunal, because correction and everything
Yes.
comes
That has
under
to
the
be
tribunal.
done to the tribunal.
Land
I will
tribunal.
not be praying before this court.
No, your name is recorded there. Your name is already recorded in the record of rights.
Yes.
In the record of rights,
Come to your writ petition. Your
Yes. It has been
My-
claimed therein. Claimed therein. Averment is there. I have also gone through.
my writ petition, Miller.
That yes, in the writ petition, some in paragraph 3 or 4. It has
Yes,
been-
I have always dealt with LR 321, 322, 323. That I also told your lordships. Miller.
So what will the BLRO do now?
Now the BLRO will be matching with the LR and RS. I'm sorry. BLRO এখন কি করবে?
আরএস আর এলআর মানে আরএস এন্ড এলআর ম্যাচ করে মানে আরএসটাকে কনসিডার করে এ করবে।
সেটাই তো অমূল্য তো সেটাই বলছে।
হ্যাঁ, আমার কোনো আপত্তি নেই।
এলআর
এই তো
এলআর
বলছি।
এটা উনিও মানে বলেছেন
তবে
ওটা
এটা তো সাবসিকুয়েন্ট রিয়ালাইজেশন।
এটা ভিডিও
On the date of আস্তে on the date of
এটা
inspection.
ভিডিওতে বলেছেন উনি।
উনি বুঝতে চাইছেন এটা মামলার পরবর্তীকালে উনি
আপনি
বুঝতে
বসুন,
চাইছেন।
An order dated cannot be passed by us. Na?
Not rejection, he did not reject.
Direction.
Yes,
Upon the
I say,
ba-
Miller, that if he considers the representation.
we have ensured that you are protected so that you can.
By the police, yes.
Yes, next.
I'm grateful.
Disposed of.
But your lordships have kindly also consider, Miller, kindly give one observation that your lordship.
Two lordship, I beg to appear on behalf of the petitioner. My lord, we have sent, my lord, through email, they have received, as well as by post, my lord, yet to, my lord, confirmation report. Postal document, my lord.
Which for the state.
We have effected service, state effected
Why
service.
didn't you make Union of India party?
My lord, because of this is done by the Odisha government, I don't know, my lord, whether at the instance of the Union of India or not. That is why, my lord. My lord, may I hand over the affidavit of service, my lord? My lord, as far as mail is concerned, they have received.
When did they receive?
My lord, immediately receive on the date of affirmation of the affidavit. That is, lordship, on 4th July itself. 4th July you have affirmed it, and 4th July they have received it.
Today we are on 10th.
We are on 10th.
The state is not representing.
State by hand.
Received.
Received. That is here, my lord. This one. This other copy. The 48. 47 নিয়ে কথা বলছি 47.
What is the matter, Mr. Chakur?
My lord, they are the migrant labor. My lord, the citizen of India went to, my lord, Odisha for a considerable period of time. And, my lord, they have arrested on 30th, my lord, my lord, the son of the petitioner arrested on 30th June. And thereafter, my lord, kept him in a detention center. And whereabouts of that, my lord, the son is not available with us. We have made representation. They are illiterate people, belongs to the downtrodden community at Hodihorpada, my lord, the Murshidabad. We have made representation to the respective arrested in Jagat Singhpur, Odisha, my lord.
You have filed another matter, no?
That is relating to pushback, my lord. That is arrested from Delhi.
Oh, that is
arrested from Delhi, and then, my lord, it is reported to us, possibly, my lord, through the help of the open border, my lord, they have sent to the, my lord, the Bangladesh. Yesterday evening, we have received that information. Alarming situation, my lord, subject to correction.
Have you, did your junior take instruction? Who is the advocate?
And I have
engaged?
taken that instruction, Rana Mukherjee,
Rana Mukherjee.
for the so far the state is concerned.
Call Rana Mukherjee. Where is Rana Mukherjee? Rana Mukherjee আছে বলছে। না। কেউ নেই। রানা মুখার্জি। শয়তান দেখে। Receive করে। Rana Mukherjee engaged, you know?
Yes, my lord, I have inquired. I have inquired. In one matter engaged, and one Mr. Tiwari is engaged in another matter. I don't know, my lord, which one. 47, 48, both, my lord, Horiharpada, resident of Horiharpada, both, my lord, picked up from Jagatsinghpur, Odisha, and kept in a detention center. There are some people at the same breath, they are released, but these two fellow are yet to be released. My lord, no production.
So you
Yes, I
said
have
for
sent-
Rana
I
Mukherjee
have said,
that court wants his presence. বিশ্বকে email
him, all of them, my lord.
you inform him, you
Yes.
inform, we are directing you, you inform the GP's office.
Lordship,
If nobody appears, then we will deal with it.
Lordship, deeply honest.
Come at 12:30. Inform Raja Mukherjee, court wants
Rana
him present.
Lordship,
Rana Mukherjee.
deeply honest.
You check up who is the advocate.
Lordship,
And if the GP is there, you tell him that the court wants their presence.
Lordship.
My lord, I appeal for the appellant, my lord. With regard to mutation in respect of solid.
কোথায় গেল?
Yes, my lord. I bring the record on.
হ্যাঁ এটা আবার কি? Where is Oyun Banerjee?
He's coming, man. He's on the way, man.
আমি
GP.
আচ্ছা Ms. Roy Choudhury, just one clarification we wanted. If you kindly come to the impugned order.
My lord.
আমার কথা মতো নেই।
Yes, ma'am.
That is at page, internal page 9 of the, no, sorry, internal page 70
Internal page 17.
of the order impugned.
My lord.
This paragraphs 18.
18.
What is this?
My lord, this was not my case, not the case of the respondents either in their affidavit or in the course of argument, or it did.
Is it a fact? Is it a fact?
My lord, I've checked up. It is a fact. It is with his brother, Mahesh Kumar Goel. He is a co-sharer. Co-sharer, my lord?
Co-sharer in same property?
No, it is of a different property, my lord, EC 149.
Pardon?
It is in respect of a different property, which is in the possession of his brother, EC 149.
You are in, your plot is in sector 1.
Yes, sector 1.
More than 4 cutters.
More than 4 cutters.
Sector 1. Now this is also sector 1.
This is sector 1, EC 149.
What had been the fate of this mission?
My lord,
the learned judge has, this has weighed with the learned judge. That on verification I find
yes, my lord, the learned judge carried on verification so motu, my lord. And the first time, my lord, and the first time, my lord, it has come surfaced in the judgment itself.
Can you apprise us, madam?
My lord, as far as I have been told, my lord, this matter was finally disposed of by judgment of Honorable Justice I.P. Mukherjee, if I'm not mistaken, my lord. And a mutation was granted to be effected in respect of the whether it has been actually mutated or not. I do not know, because the relationship between the two brothers is not.
This is that Sudhanshu affidavit you are giving.
Yes, my Sudhanshu affidavit, and along with my lord, the two affidavits, my lord, Sudhanshu Ranjan Chakraborty, Gauri Chakraborty, and another Pratap Chandra Sinha.
Sudhanshu Ranjan Chakraborty, Pratip Chandra Sinha.
No, Sudhanshu Ranjan Chakraborty, along with my lord, Gauri Chakraborty. Both
the husband wife.
Husband wife.
And those they gave it to Pratip. Pratip gave it to them.
Man,
Yes.
Pratip also given there, my lord. The affidavit is there, my lord.
Well, the original.
Also there. He is stating that only 4.39 katas, no land is there, my lord.
Over, my lord, but my case remains unaltered.
No, we are not saying that you are taking a different stand. We are not on that. কেউ কবে ব্যাপারটি কবে একটা কি বলবো
Malo, the crux of the matter was, well, 19th of December, there was an assault committed upon the petitioner. My lord, she was to be taken to a hospital. She was to be hospitalized. She was to be hospitalized. My assault committed on the petitioner. She was to be hospitalized. Thereafter, she was discharged. In the meantime, my lord, the assailant has also, my lord, lodged an FIR. We went and we also lodged an FIR. There were counter FIRs. The petitioner's husband was arrested. Thereafter, he was also discharged on bail, released on bail.
Writ petitioner's husband.
Writ petitioner's husband. Present appellants. Present appellants. Durga Sharma.
So your husband?
Yeah, my husband, my lord.
Released on.
Released on.
Yes,
This is the crux of the matter. Now, what happened, my lord? In the meantime, my lord, when I was in hospital,
for the private respondent.
my lord, we have served.
Service.
Yes, my lord.
Achha.
We have served, my lord. In the meantime, my lord, what happened, my lord? I have a minor daughter.
Achha, will you place the order impugned first?
My lord, may I phrase the crux first? There, my lord, I'll place the order.
Okay. Then what happened?
My lord, I have a minor daughter. My lord, I come to know because in the meantime I was running for my husband's bail. My lord, I come to know she had got silent for a few days and was under some mental trauma. And I come to know she was manhandled and my lord, she was also assaulted. My lord, I lodge a complaint. After my husband comes back, there is a delay. I admit that there is a delay. Now I filed the writ petition on the crux, my lord, that the FIR should be lodged on the POCSO Act. This was my prayer before the learned trial court, my lord, learned writ court.
What is the age of your daughter?
My lord, 13. My lord, charge sheets have been filed in those cases. No initiation of, my lord, investigation in the present complaint. Now, there are few flaws, my lord. I must admit in that. What has happened?
The single judge.
My lord, he gave a direction that because the charge sheet was filed, I may file application under section 193(9). Naraji petition.
Naraji.
Now, my lord, even if I go and file a Naraji petition, my lord, because it's a separate offense on a separate individual, my lord, separate FIR has to be instituted. Now, as on today, my lord, what I am on?
Yes.
May I? My lord, there are certain flaws on behalf of the petitioner. Number one, my lord, there was a delay in lodging that. Secondly, my lord, a 164.
You did not say anything.
Yes, my lord. I admit that.
Was the
Why, my
examined?
lord? I also have a reasoning for that because, my lord, whenever I went up to that police to say that these are the assaults that these are the atrocities committed on my minor daughter, they said because the FIR has been lodged on my complaint, the atrocity that has committed on myself, you say whatever it is to be done. That is a separate case. We'll deal with that later. Now, as on today, my lord, yes, my lord, I admit that that is a flaw. When she has an opportunity, she should have told.
The thing which you have not mentioned in the complaint.
But later on,
thing which is not disclosed in course of 161.
164, my lord. Even
it is better.
Yes, my lord. It is better.
64.
I admit that.
But your daughter has been.
What I am today, my lord.
Sir, how do you explain this?
Lord, the complaint appears at page 44. The letter complaint of this. The letter complaint.
Letter complaint.
The complaint about the daughter, the minor daughter.
When was the first complaint lodged?
My lord, the first complaint.
20th December 2024.
20th December, my lord. Page 37.
Very good. Then in this there is no allegation as regards your
No,
daughter.
no, no. There's only allegation my daughter was assaulted, nothing on that even.
Achha, then when did you file the next complaint?
My lord, 28th of January 2025.
Where is that?
Page 44.
40?
44, my lord.
28 December को
So this was registered.
No, my lord.
Naturally, you will be having a problem.
There are flaws, my lord. What I pray, my
What
lord.
you want from us?
Yes, my lord. What I pray, my lord. I pray that the girl's statement may be recorded by the police as well as the magistrate, and if there is a case, my lord, let the police investigate and file a report,
Yes,
my lord. If
madam.
I only for that, my lord.
My lord, we inquired and we registered one complaint, my lord, on 19th February 2025, as per our report. My lord, I want to file one report where your lordship
The
can get the
19th February 25 on the basis of the complaint lodged for
while they are trying to lodge complaint that my
Then what
daughter.
happened? What happened?
My lord, we asked for some documents, that whether any documents or not with that from where we can come to know that it has been happened, but they didn't produce anything. My lord, last page of my report just come on 24th, just before last page, man. Yes, one more copy for the second.
Yes.
Page 3.
Court complaint. So that was not treated as FIR. You 156(3) you moved.
This is with regard to a separate incident that the petitioner was being traumatized. They were still being threatened. This report, my lord, which the police is relying on now today.
No,
The state
this is report today I am filing after receiving this appeal, my lord. It's a new report.
No. Is this on the basic page 44 of the stay application?
My lord, that I am want to
On this
clarify that on yes, my lord. On 24th June 25, 24th of June 25 at 10:15 hours, means at night. Third page, my lord, of my report. Last line from last, just before.
On 24th June.
My lord.
Yes.
Yes. Has received a court complaint from Durga Sharma, wife of Vikas Sharma, resident of Kharida, Munga, Shed Bari, PS, Kharagpur district, Paschim Medinipur, by MP case number 37/2025. The complainant alleged that the complainant was registered a case against following accused person bearing KGPT PS case number 533/24 dated 20th December 24 under section 319(4), 115(2), 76, 324(4), 303(2), 351(2), 35 BNSS. Since the case was started, the accused have been pressurized to complainant and her husband in various ways to take up the case. But since complainant did not agree to take up the case, the accused are threatened complainant with various threats, including threats of murder. Not only that, the accused are threatening to forcibly take away complainant's minor daughter for physical assault. While this was going on 19th February 2025 at around 2 p.m., when complainant was busy with the work of Shonidev Mandir in front of the house with complainant's daughter, the following accused came to complainant and started abusing and pressured her to withdraw the case. That complainant had failed KGPT 533/2024. But when complainant refused to withdraw the case, the accused mentally and physically abused complainant and complainant's minor daughter. They pulled complainant's daughter by land. Then the temple priest and local people stopped the accused. And when they wanted to know why they were doing such a thing, the accused also threatened them. But under pressure from the local people, the accused then left, threatening to leave, saying that they will be face severe harm in life. According to the case endorsement, SI Malloy Roy of Kharagpur Town PS took charge of the investigation. Investigation is going on. Photostat copy of FIR F.
What going on, madam?
It's
Your
an
PC
investigation.
himself says that she was threatened.
My lord,
Guard
we are
was heckled.
investigating. My lord, kindly, we have taken the first FIR, my lord. Annexa Ref.
Yes, yes.
Yes, so we have taken the steps accordingly, my lord. And investigation.
What about the other portion? You have not lodged any POXO case.
My lord,
that was not the complaint.
My lord.
You are right.
My lord.
Now you yourself, you say that when on 24th of June, on receipt of a court complaint,
my lord, where it has not been revealed. Court complaint where it has not found that has happened, my lord.
Court complaint means, did you file any, what is this MP case number
This is
37
with
of
regard to
25?
the continuance of atrocities committed after filing of this writ petition.
That
is a different.
So they didn't raise that their daughter has been assaulted by that accused. This has not happened. After that, it has happened, and we are investigating this matter. Annexa Ref, my lord.
This report even that my learned senior friend had placed does not even disclose that they had taken into the consideration of my complaint or the incident of that day.
My lord, Annexa F is the Annexa F of my report is that FIR where we are investigating.
Not on the basis of the first complaint.
That has taken, we have taken step, and that's why single
Did you
judge
file
viewed.
any charge sheet in that? No charge sheet has yet been
My lord, filed before court below, my lord. That's why we single judge viewed. Yes,
Both the cases charge sheet had been filed, my lord.
B2 Annexa B2, my lord.
I have disclosed everything. Both the cases that
Charge sheet has filed. That's why single judge
as well as the other
view that if you are not satisfied with that charge sheet, you can file Naraji.
That is a subsequent incident which has occurred now. From your report itself,
after that, they are raised.
Your charge sheet was submitted on 20th of December
21st December 2024. 31st December 2024. Annexer B2. Annexer B2 of my report, my lord.
Very good. Now, this next episode that she was being threatened, this was communicated by a separate.
Now we are investigating that portion. That's why we have, my lord, FIR has taken. This is under process. That whether it has happened or not, we are investigating, my lord, because there was peace. We are inquiring the peace.
You are without registering a case. How can you investigate?
Well, FIR has registered, my lord.
Oh, that FIR has culminated in a charge sheet.
Second FIR, my lord.
Second, you have not registered and you have registered
my
an
lord,
FIR.
Alex, kindly come, Annexer F, my lord.
That is page?
Last day of my report. Last page of my report.
Last page?
It is Annexer F. Last page.
No, this is 24th.
FIR number 300 2025. Date 24th June 2025. After raising the issue, my lord.
300.
They have given the POXO Act. What you are saying?
That's why
I am not aware of it. I am not aware of it because I was never communicated with it.
We have taken.
Give him a copy. May I even take the number? I can download it and get the certified copy.
We have taken.
T20. 300. Dated.
24 June 2020.
Statement নিয়ে এসো মেয়ের মেয়ের statement
সবার নিচ্ছি তো আমরা investigation is going on.
Then I don't, the FIR is instituted. If they do an investigation, then I don't have a case.
So even itself this appeal doesn't lie, my lord, because issues, they can come challenging this order. while this issues has not been raised in that single bench. This come later. So it is not maintainable. So it is separate proceedings. It has started after receiving that complaint.
Have you filed Naraji in that?
According to they can, yes. That direction that you are not satisfied with that charge sheet, you can file Naraji.
I've challenged the charge sheet, my lord, that is filed against me by way of a revisional application that is pending.
No, your grievance is that subsequent thereto this has happened.
This has happened.
I have gone and complained.
Yes, my lord.
They have not registered a case.
Or
That
had
is
not taken the statement. Now, my lord, they have
that
registered.
is a fresh cause of action. We will record that on the basis of your subsequent complaint.
Yes, my
criminal
lord,
case has
I
been
don't have a case
registered.
now.
Record, but in appeal they can raise these issues.
No, my lord, I've
that
taken this issue, my lord.
has not been
my lord, I've-
raised in that single bench.
My lord, I've taken that point
It's a
in.
separate issue.
It's a subsequent.
My lord,
Separate issue.
I have taken that point in the.
Disposed of that writ petition. They filed that complaint and accordingly the steps happened. So where
disposal?
No, my lord. This is
my lord,
no.
where
My lord, this is what is my lord is going through annexure P3 page
order passed
44.
by single judge on 19th March 2025.
44, my lord.
My lord, order passed by single judge 19th March.
This is a part of the writ petition.
Kindly come to page 44. 44.
Page 44 is a part of the writ petition, my lord.
That time they didn't do this, my lord.
This complaint was there.
Even my prayers, my lord. Even my prayers in the writ petition at page 13. It starts from page 13.
All right, we shall say we question
taken
of
steps already.
interference with the order does not occur. His grievance is this. On the basis of
We
that,
have
you
taken
have
steps.
registered a complaint and investigation is on.
Going on, my
In
lord.
view thereof, we are not interfering with the order.
My lord.
The present appeal has been preferred. But madam,
of service. An order under section 14 passed by the district magistrate was challenged before the DRT.
What's up?
The impugned order.
Yes.
An order under section 14 before the DRT was challenged under section 17. On the pretext that the 9 counts which has been stated, which has to be satisfied before the district magistrate, were not satisfied, the order under section 14 was set aside, passed by the DM, was set aside by the DRT. Bank preferred an appeal before DRT. DRT also, after being satisfied, affirmed the order passed by DRT. A writ petition, bank preferred a writ petition before the Honorable Court, the learned single judge, allowed the writ petition, stating that.
What did they challenge?
The order under section 14.
Oh, achha.
The order under section 14, which was set aside by the DRT, thereafter it was affirmed by the DRT, was challenged in the writ petition in the High Court.
Oh, challenged in the writ petition, that order of the
DM. That order was challenged before.
That has attained finality.
That has attained finality today. That is the
so
main.
they did not challenge the order passed by the DRT.
No.
Challenge to DRT. DRT order was not assailed.
DRT order was not settled.
Yes.
Today the whole difficulty is.
Well, it is not like that, my lord. DRT order was only challenged.
We shall come back. Yes.
My lord, comes to the impugned order.
DRT order was challenged by way of the writ petition.
Yes, my
By
lord.
way of a writ petition.
DRT order only.
Original impugned order was the DM order was challenged. That was set aside.
Yes.
May I read the impugned order?
Yes.
Impugned order, my lord. In the present writ petition, the petitioner bank challenges the order dated 2nd of February 2023, passed by the Debts Recovery Appellate Tribunal in Appeal number 263 of whereby the learned DRT confirmed the order order dated 1st of October 2018, passed by the learned Debts Recovery Tribunal 1, Kolkata DRT in SA number 158 of 2015. By the said order, the learned DRT had quashed the order dated 23rd of July 2015, passed by the learned district magistrate under section 14 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, herein after referred to the survey. Though the learned DRT found that the reasoning of the DRT was faulty, it nevertheless proceeded to confirm the order of DRT on different grounds. Facts of the case. The petitioner bank sanctioned.
So take us to the relevant portion.
Relevant portion, my lord. Let us come to the relevant portion of them. My lord, comes to the inner page 15 of the impugned order.
Just one.
Right. The ordering portion starts from page 13, my lord, of the impugned order.
Sale had already been
after the sale. After the sale, we had challenged the section 4 under section 14. An order was passed by this honorable court where notices were not 13-2 notice, nothing was served to us. We had, after the order was passed under section 14, it was served when possession was to be taken over. We can
13-2 notice was not served.
Not served.
These are new case. These are new case for the first time raised by my lord.
Justice
Take a new case. What is your problem, sir?
I am the unfortunate auction purchaser. 25 lakhs, a lady, septuagenarian lady, now at 75 years of age. I purchased this property for a sum of rupees 25 lakhs in 2014. Now with the rigmarole of events where bank is running from pillar to post and the appellant has not even challenged the sale order, auction sale order. I am suffering. Now I want my money back. I'm neither getting money nor lordship. I'm getting possession. And now I'm 75 years of age. From 2014, my lord, because of this litigation between the bank and my lord, and the borrower has not even challenged that sale order. So the degree stands against him. Now he is challenging the execution proceeding, if I can put it in the way of civil proceedings. The sale certificate has not been challenged. The
Sale has been confirmed.
Yes, my lord, I am the sale certificate holder. I have purchased, I have paid 25 lakh odd in 2013.
And the auction was conducted.
My lord will kindly see, I'm just giving my lord, 13-2 notice given on 9/1/2012. And no objection was filed. 9/1/2012.
Very good.
13-4 Surface Act dated notice was given on 12/7/2012. Now, Lordship, property was auctioned and purchased by me for 25,35,000 and a sale certificate was issued to me on May 30, 2014.
No, just before that, 13-4 is of 12th of July 2012.
Lordship.
Then when is the order of the DRT saying affixing liability on him?
Lordship will kindly see the. I'm coming to my lord. I had my sale certificate was issued on May 30th, 2014, which is not challenged yet. Neither the borrower nor the guarantor has challenged the sale.
When was the auction held?
Auction, my lord, sales. I'm coming, my lord will kindly bear me. My lord will kindly come to page 2 of the impugned order. The factual matrix has been specifically given. Page 2 of the impugned order. If my lord kindly reads the third, lordships kindly read the third paragraph. Consequently, a demand notice under section 13(2), lordship, of the Surface Act was issued on 19/1/2012. No objection to the said notice was either filed by the borrower or by the guarantor. The possession notice under section 13(4) of the Surface Act was issued on 12/7/2012, which was duly published in newspapers. Subsequently, the petitioner bank obtained valuation report of the secured assets from their impaneled valuer. Thereafter, a sale notice was published on 3/3/2014 in 2 leading newspapers, The Times of India and Ajkal, involving the auction of the mortgage property. A copy of the newspaper notice was also served on the borrower. Nothing done by them. Pursuant thereto, the auction sale was confirmed in favor of the respondent number 5, Srimati Bhagwati Oja, that is my client, for a total sale consideration of 25,35,000, and the sale certificate was issued in her favor on 30th of May 2014. Neither the borrower nor the guarantor has challenged the possession notice and the said e-auction sale notice dated 30/3/2014 within the limitation period. Accordingly, the loan account was closed. Now, my lord, this is the brief fact. Now, my lord, I have purchased it. Now, my lord, there was a technical defect in the order passed by the learned magistrate. If we are on the same page for this point of assuming. There was a technical defect saying that instead of authorizing, he authorized the Commissioner of Police. Now, my lord, they challenged that order before the learned DRT. DRT set aside section 14.
Passed by
Section.
Honorable Court.
My lord, my lord, I take the responsibility. On fact, my lord, I will not say anything which is incorrect. Now, my lord, section 14 was challenged before the learned DRT. DRT set aside it on a technical ground that the commissioner should not be authorized. Now, they could have, my lord, I'm not going to advise the bank, but for me, my lord, I would have made a separate application under section 14 correcting that mistake, because the DRT said that you correct your mistake. It was not that the sale was set aside by that order. But in all the...
When did this happen?
My lord, in 2014, 2015, my lord, the DRT order was set aside. They assailed that order before the DRAT. Now, that DRAT matter was decided in 2022. They came before the Honorable High Court in 2023. The bank left the matter pending, writ petition pending before the Honorable High Court from 2023 to 2025. Then we made an application before the DRAT that please give me back my money. Now, with my age, I need medical sustenance more than my house. Because when I purchased, I was 63, 64 years of age. At that point of time, I had in my mind that I have my own house. But no, my lord, I am spending a lot of money on my medicine. 75-year-old lady, my lord. Now, because of this particular clash of the two litigants, my lord, I am neither here. Now, my lord, now when the Honorable Single Judge came to this finding that all right, that order passed by the learned magistrate was right, I was again hopeful But again, the whole process has not been expedited. Again, I'm suffering. My lord. My case is that let it go anywhere, lordship. But my 25 lakhs, even if I would have kept it in a fixed deposit, lordship, it would have earned me certain amount of interest. But here, the bank is saying, since you have given the money for a particular property, the property has become non-performing asset for me now. My lord, this is my lord. I apologize, my lord, for barging in. My lord, just
Show us the reasoning portion of the
my lord, they'll kindly come. My lord, they'll kindly come to the.
Starts at page 16.
Lights will kindly come to a legal analysis that starts from paragraph 16, my lord. The pagination, my lord, I have got a copy which is not, my lord.
No, not page. Kindly come to page 17.
Lordship of the impugned
There
order.
are 27.
Yes, ma'am.
Huh?
Not adverting to the facts of the present case, it is evident that the borrower.
Para 27.
Para 27 of the impugned order.
Now adverting to the fact.
Now adverting to the facts and facts of the present case, it is evident that the borrower guarantor did not raise any objection to the proceedings initiated by the petitioner bank under the provisions of the SARFAESI Act. The auction sale was duly conducted. The sale certificate was issued. A symbolic possession was taken over by the bank and the loan account was closed upon adjustment of the sale consideration. However, when the bank sought to obtain actual physical possession, sale was confirmed. Thereafter, Section 14 application was filed. It's fact. 2012.
You did not, and the court was not satisfied with your conduct.
Well, 2014, we came up before this High Court where liberty was given to approach the DRT.
Very good. You
Well, an order was passed by Justice Dotto. We approached the DRT challenging the order of Section 14 under Section 17. That is also gives rise to file a application under Section 14, Section 17 before the DRT, my lord.
No, we understand, but these facts are very ugly, sir. 2012 was the process initiated, 13 to notice. Show us any single document that 13-4, 30. You just had been a silent spectator, sir.
Well, it's the fact that the
how can we
actual
help
borrower,
you?
the actual borrower, the
We are in
original borrower,
judicial
these are the legal heirs of the borrower. The the petitioners before the DRT and the DRAT or before the High Court were the legal heirs. The notices were.
The petition was also not, my lord, contested by them before they land a single bench.
Not contested.
My lord,
the impugned order.
Yes, my lord. On the last occasion,
duly appeared.
On the last occasion, my lord, on the last day, my lord, they appeared, my lord, but
they were.
My advocate on, I am Arun Kumar Boral, my advocate on record was there. When it was served, my lord, after the amendment, it was served to us. On the first day when it was served, thereafter we had appeared.
Mr. Boral, tell us on what ground we will interfere. Finished.
My lord, the ground before the Section 14, the 9 counts. If my lord takes up the Section 14 order.
What is your prayer? Today you will have to, abiding by the bank has to again go and file Section 14 application.
My lord, if my lord takes
they
up,
ought to have done earlier.
Yes, if my lord takes up the Section 4.
Bank's fault, you cannot take advantage.
No, I am not taking any advantage.
Exactly, that is what you are doing.
The authorized officer is directed to, if the impugned order, if my lord turns to page 18 of the impugned order, page 18, paragraph 16, paragraph 36, my lord. The authorized officer. The authorized officer is directed to take possession of the assets expeditiously as possible page 18, my lord. Page 18, paragraph 36. Today, my lord, the DRT has set aside the section 14 order. It has not been restored until and unless a new proceedings is being initiated. How they can take possession, my lord? That is a question which I am asking to myself. The 9 counts under section 14 has to be satisfied. The court, the DRT.
Mr. Bodal admitted that order was bad, rightly affirmed.
Right.
Court has gone into the facts of the case.
Facts of the case.
Now today we are in judicial review.
Judicial.
Even a plausible fact we cannot interfere. Had it been a total, what should I say? It's a total non-application of mind. We could have understood. Give us any authority to that effect.
No,
Very ugly facts, Mr. Bodal.
Tomorrow can I come back?
Abar bole
with some authorities. There are some authorities, my lord. My lord, section 14 order. My lord, section 14 order, my lord, there are certain line. If my lord, section 14 is my lord,
For 13 years, she's out of pocket. For 13 years, you've done nothing. You've enjoyed.
Well, the 14 order, the 9 counts has to be initially satisfied before the district magistrate.
Except for that one technical glitch that instead of the commissioner, it ought to have been the authorized officer.
That apart, my lord, section 14, there are 9 counts which has to be satisfied before that. That was not at all satisfied. That is my submission, respectful submission. Section 14, 9 counts has to be satisfied, my lord.
Now a vacant flat.
No, they are in possession, madam.
They are in possession. Therefore,
the
Milord, they are taking advantage of all these things. And Milord,
Bodal, vacate within a certain time. Keeping the
my lord, if my lord takes up once section 14, once, my lord, section 14, one.
my lord, fight between the bank and them, Milord.
That the proviso part has to be satisfied, my lord.
My lord, before the section 14 is to be taken up, may I just give one reference for the fact? Perhaps both of my learned friends missed out. My lord, this matter was initially challenged by them before this honorable court. Before Justice Datta, that order was passed. And there was a specific finding about the sanctity of that order, my lord. And that finding was never challenged. They only sought the liberty. By way of the liberty, they filed before the DRT. But so far the sanctity, yes, but so far the sanctity of that part, the order, my lord, this section 14 order of the magistrate is concerned, my lord, there has been specific finding. If my lord kindly comes to that, my lord, this finding once, my lord.
Takes up page 57 of my Annex P7 of my.
That is a very, my lord, that is very order that has been.
Let him finish off. Yes.
My lord, which I was placing, my lord, section 14, the proviso part. If my lord.
Yes, yes, place it.
Proviso part, provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer. May I hand over? May I hand over? May I?
Yes, what is your point?
The proviso part, my lord, the section 14, the proviso part provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer or the secured creditor declaring that the aggregate amount of these 9 counts were never been put before the district magistrate, my lord. These 9 counts are there, my lord.
We listen to your 9 counts, you vacate first. You vacate, we listen to 25 counts. Why 9?
Sir, you vacate?
Yes, first.
Tell us when will you vacate?
Might come back tomorrow morning as a fast item. Let me take instructions from my advocate on record or the appellants be present over in the court, my lord. That would be
tomorrow morning. You'll come and say when you want to vacate,
my lord. I have to take instructions from my advocate on record and also from the appellants, my lord. This 9 counts has never been satisfied. It's a fact.
Admitting. Still, Mr. Bodal, your conduct, and why should we allow the lady to die? 25 lakhs 2014. You are enjoying the property. In this sort of cases, if we interfere, Mr. Bodal, then you're before an equity court. Mr. Trivedi was sleeping. He did not take appropriate.
No, Milord, I took steps, Milord. If my lord given a chance, I will.
Tomorrow to be mentioned.
My lord, my conduct was always, my lord, very fair, but my lord, a poor lady, my lord, what?
In course of hearing, Mr. Bodal, learned advocate, yes, Mr. Mukherjee, where were you? Where is the petitioner?
নাম বলো তো রাজ্জাক শেখ
টু হচ্ছে রাজ্জাক শেখ
Notification is yes. Yes,
Lord,
place your case.
Lord, I'm placing, my lord. One Saniur Islam, my lord, for a considerable period of time, my lord, for want of job, my lord, was in Odisha and doing his, my lord, avocation there. And on 30th June 2025, during, my lord, the so-called identification drive, my lord, he was arrested. My lord, arrested, identified by, my lord, the linguistic minority, since he is speaking in Bengali, that is why he was arrested. And thereafter, my lord, since 30th June, my lord, he was not produced in any court pursuant to the provision laid down under the Article 22(2) and other relevant statutory provision. My lord, no custody memo, nothing of this sort, no communication to the respective family, as a result of which, my lord, being aggrieved by, my lord, the family father of the, my lord, the detainee, Razzaq Sheikh, before this honorable court, and, my lord, seeking, my lord, the part of cause of action arising over here, my lord. And, my lord, they are helpless person, my lord, for want of, my lord, job and other thing. They are, my lord, they can move every part of the, my lord, the country in terms of the constitutional provision. They cannot be held in this fashion. It's an illegal detention. Lordship, kindly recall the D.K. Boshu judgment. My lord, there are number of guidelines issued by the Honorable Supreme Court not adhered to, and illegal detention is going on, my lord. Our humble submission, my lord, immediate production and, my lord, declaration the detention is illegal. At the same time, my lord, the compensation and, my lord, disciplinary action against the hearing, my lord, those who are doing all this mischief. Not only this incident, my lord, the other matter is also the same thing. Tomorrow, my lord, two matters are fixed. Number of persons, my lord, they are harassing in this fashion, my lord, in this way. Not only Odisha, in different other states also. Here, my lord, we, before this honorable court, with this particular plea, my lord, of habeas corpus for their production, release, and all these things, my lord.
Yes, Mr. Dutt.
My lord, I am appearing, my lord. My lord, I am appearing. I am appearing for the state.
Yes, Mr. Dotto is also here.
Oh, Advocate General is there. Oh, it's all right. All right, sorry. I have not been informed. Sorry. Let him appear. Let him appear.
Milord, here, Milord, the state is ready to, Milord, give whatever help required.
Mr. Dotto, has this state government has contacted Odisha?
Milord, my instructions, immediate instructions are that there is no official communication. One thing I can suggest, subject to your Lordship's consideration, your Lordship may appoint a nodal officer or some officer who will coordinate with the appropriate persons, Milord, in the place where they are detained. And state government, either state government appoints an officer or, Milord, the ADG law and order can be also deputed from our side, who will coordinate with the nodal officer, whatever special officer, whatever, Milord, your Lordships are pleased to, Milord, appoint. And, Milord, they can, Milord, interact with each other primarily because what appears to be that their identity and their place of residence is the main problem. So whatever is required to convey their identity from the side of the state, our state, will be done so that, they can be released from.
They're permanently residing at Horiarpada, Murshidabad. Father wrote a letter addressed to the appropriate authority
So
of
the state
local.
will cooperate in providing whatever information is required.
Look, look, can I add one sentence? Can I add one sentence? Can I add one sentence?
Yes, Mr.
Milord, not only one incident. What has happened, as it appears from today's newspaper, 200 Bengalis have been detained by the Odisha. And Milord, in Assam also same are doing. Even the Bengalis who are going to Odisha for some job, they are being detained. A very serious issue has come up.
The present petition has been filed against the respondents, including Odisha,
Yes, yes, I'll expedite.
My lord, item number 3 is same, my lord. Item number 3, 2, my lord, lordship dictated. Item number 3 is also there, my lord.
Item number, we didn't say, respondent numbers.
No, my lord, another matter is there.
Next matter.
Nasim Ahmad.
Nasim
What
Ahmad.
is the name of the other?
Here, my lord, the name of the detainee is Rakibul Islam.
Rakibul Islam and same.
Yes, my
same.
lord. Same police station,
Jagat
Jagatsinghpur, everything same.
Same order in force.
This is the affidavit of service.
Affidavit of service as filed.
Also same.
12 and 13 also same. I don't know. Mr. Chakraborty, you are appearing?
No, my lord. Tomorrow, other 2 matters are there, my lord, listed.
This is of
তোমার এও আর কি
স্বপ্ন
তোমার এও আচ্ছা এটা কি
কালকে যে দুটো আছে আমি
এটা তো এখানে হলো না ওই তো এই দুটো আছে
এই 12 item 12 টা বের করো না কে
12 13 তো তোমার না লর্ডশিপ দিস ইজ দ্য অ্যানাদার ম্যাটার 12 and 13
তাই বলে another matter it will be
habeas corpus নয় তো
habeas
না না
corpus tomorrow,
different
not today.
Mr. Jana, you have concluded.
Concluded, I shall rely 4 or 5 judgments.
Mr. Sen, you have to conclude today. We have up to 3 o'clock.
Lord, I'm telling you, Lordship.
Now, please don't seek adjournment.
No,
and
I'm telling you, Lordship, kindly. My Lord, on the other day, after concluding the argument, Mr. Advocate General, Mr. Dattu, said that he would, my Lord, make submission and will take another half an hour time for placing the judgments. Now, I requested my learned friend to give the citations in advance so that we can come prepared.
My Lord, we have prepared some. I have a great compilation. I have deleted all. Now I have concluded on the 4th judge.
I held a talk with my learned
How can I say yesterday night?
Mr. Sen, matter was in combined list. It was upon your mentioning we insisted.
Yes.
Last occasion, Mr. Dotto was not there. In his fairness, he started arguing.
Yes.
We fixed it today, knowing that we will finish. Now it is your adjournment, and you are giving an excuse that their judgment. Why didn't you give me?
I do not know. What shall I rely now?
Very unfortunate. Very.
No, my Lord, I am telling that.
Yes, Mr. Jana.
Yes, my Lord, one by one.
Citation could be given in advance so that I can make my submission.
That is not the procedure. Spontaneously argument has to
আমি তৈরি হলাম তো কালকে আমি কি করে দেবো আগের গুলো তো দিতে পারিনি এতগুলো বাদ দিয়ে দিই
আগে বলতেই পারতেন কি
দেখি একটা করে দাও 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 একটা একটা করে দাও আগে আগে দাও এটা দাও আগে দাও এটা সেই চেনটা দিয়ে শুরু করি সেই চেনটা দিয়ে শুরু করি আগে তারপরে যাব 66 না 66 টাকা দেখাই beyond jurisdiction.
Yes.
হ্যাঁ সব দুটো করে আছে এটা দিন আমাকে দুটো হ্যাঁ যার সাথে দুটো তিনটে আছে কোনটা দেবো এটা দি
Yes,
Milord, I had made one submission that there is no scope for enlargement of the reference. My lords were pleased to, Milord.
Enlargement of reference, the order fixing a particular date for grant of the benefits, that has been altered, though they have not preferred any appeal. You have submitted on the reference also, regularization does not find place in that reference.
The date of appointment to be treated when in reference.
And you have further submitted that the tribunal passed the order restricted to the workmen who were working, and it had enlarged that award ambit by directing benefits to be extended to those workmen who have already retired.
Retired and dead also.
Dead also.
Dead also. And Milord, it has been given a retrospective operation beyond what was given by the tribunal.
Yes.
Tribunal. Therefore, Milord, on the first point, enlargement, please take AIR 1967.
Yeah, 66 online না এটা
ঠিক আছে
হ্যাঁ ঠিক আছে
আমার একটা কপি দিন
কপি দে একটা কপি
আচ্ছা
এই তো
Supreme Court, no? AIR 1967 Supreme Court 469 8 CH इंटरवल को
8 CH ठीक है
judgment. হ্যাঁ।
But this is reported in AIR 1967 Supreme Court 469. One paragraph from this judgment.
Yeah. Yes.
But nowadays, your lordships don't have that lal khata, which were indicators that judges are coming.
Yes. Yes, Mr.
Even I have seen those.
Yes, yes, I also seen. But suddenly, I don't know when it was discontinued.
It is not decent. We bring the khatas, but we tell our persons don't
Not
say,
to-
not
not
to
to put it on the
discuss. You remember Justice Pratap Roy's that But Mr. Dotto, see how the times have changed. You are saying this thing, everybody is interested. You will still find to your surprise that advocates are on their mobile phone. They are not bothered to hear what is being said.
Where I am responsible.
The
We are
interns,
responsible.
they sit here, they are busy. Yes.
Proceeding in the order in which the arguments were addressed, we propose to deal with issues 3 and 4 first. Under section 10(1)(d) of the Act, it is open to the appropriate government when it is of the opinion that any industrial dispute exists to make an order in writing referring the dispute or any matter appearing to be connected with or relevant to the dispute to a tribunal for adjudication. Under section 10(4), where in an order referring an industrial dispute to a labor court, national tribunal or national tribunal, or under this section or in a subsequent order, the appropriate government has specified the point of dispute for adjudication. The labor court or the tribunal or the national tribunal, as the case may be, shall confine its adjudication to those points and matters incidental thereto. From the above, it therefore appears that while it is open to the appropriate government to refer dispute or any matter appearing to be connected therewith for adjudication, The tribunal must confine its adjudication to the points of dispute referred and the matters incidental thereto. In other words, the tribunal is not free to enlarge the scope of the dispute referred to it, but must confine its attention to the point specifically mentioned and anything which is incidental thereto. The word incidental means so and so. I don't think that would be required. But only adding one judgment to this, 2008, volume 2,
তোমার এটা ইটা দাও লিস্টটা দাও আমাকে
2008, volume 2, Calcutta High Court notes 858, page 858, paragraphs 9 and 10. I don't think where I need to place it. It's same thing. 858. At short on the compilation to the copy there. We had prepared a compilation, but I will not rely upon all the judgments in this compilation. Only one judgment from this compilation. I'll take it back and will for the present kindly have it. No, খালি একটাই judgment থাকবে। আচ্ছা আমাকে একটা কপি দে ভাই। দিচ্ছি না। আমারই নেই। আমার একই অবস্থা। না না তুই অনেক উপরে আছিস না গুলিয়ে ফেলিস। But this is Uma Devi. Where the first judgment, it starts from page 1 of the compilation. Please come to Millard, page 22 of the compilation. May your Lordship kindly recollects, Millard, the tribunal in this award had returned a finding that Mr. Banerjee's clients were not appointed against substantive vacancies. And the reference was whether they can be regularized if they were appointed in permanent vacancies. Just for recollection. Now please take 3 paragraphs from Uma Devi. The first one is para 13 at running page 22. What is
yes.
What is sought to be pitted against this approach is the so-called equity arising out of giving temporary employment or engagement on daily wages and the continuance of such persons in the engaged work for a certain length of time. Such consideration can have only a limited role to play when every qualified citizen has a right to apply for appointment. The adoption of the concept of rule of law and the scheme of the Constitution for appointment to posts. It cannot also be forgotten that it is not the role of the courts to ignore, encourage and approve appointments made or engagement given out of constitutional scheme. In effect, orders based on such sentiments or approach would result in perpetuating illegalities and in jettisoning of the scheme of public employment adopted by us while adopting the constitution, adopted by us while adopting the constitution. The approving of such acts also results in depriving many of their opportunity to compete for public employment. We have therefore to consider the question objectively and based on the constitutional and statutory provision. In this background, so and so constitution bench. I skip over the quoted portion. Now please take Willard paragraph 26. With respect, why should the state be allowed to depart from the normal rule and indulge in temporary employment in permanent posts? This court, in our view, is bound to insist on the state making regular and proper recruitments, is bound not to encourage or shut its eyes to the persistent transgression of the rules of regular recruitment. The direction to make permanent, the distinction between regularization and making permanent was not emphasized here, can only encourage the state, the model employer, to flout its own rule and would confer undue benefits on a few at the cost of many waiting to compete. With respect, the direction made in para so and so is to some extent inconsistent with conclusion in para so and so. With great respect, it appears to us that the last of the directions clearly runs counter to the constitutional scheme of employment recognized in the earlier part of the decision. Really, it cannot be said that the decision has laid down the law that all ad hoc, temporary or casual employees engaged without following the regular recruitment procedure should be made permanent. Then this is what the Supreme Court is saying, that the government should be aware of. Then the last paragraph is para 33. It is not necessary to notice all the decisions of this court on this aspect. By and large, what emerges is that regular recruitment should be insisted upon. Only in a contingency can an ad hoc appointment be made in a permanent vacancy. But the same should soon be followed by a regular recruitment, and that appointments to non-available posts should not be taken note for regularization. The cases detecting regularizations have mainly proceeded on the basis that having to work for some period, he should be absorbed without really laying down any law to that effect after discussing the constitutional scheme for public employment. Or in other words, my respectful submission is, beloved, when the tribunal returns this finding that they were not appointed against substantive vacancies, the concept of regularization is inapplicable.
Yes.
And in our case also, apart from the unfair labor part, the tribunal proceeds on the basis that since they have continued for a substantial period or several years, therefore they should be absorbed or regularized. Now this runs contrary to paragraph 33. Though Supreme Court says that no, why do you make ad hoc appointments in permanent posts? In our case, it's a better case. I mean, from the side of the employer, we have not appointed them against any permanent post. That is the finding of the tribunal itself. Therefore, even if it is ad hoc or whatever, then it does not lay down the law that they have to be regularized. And my case stands on a better footing because I have the mandate of the tribunal, which has not been challenged by them, that they were not appointed against substantive vacancies.
Yes.
But the next point which I have urged is that an absorption cannot be made from a back date. I absorb you today, you are entitled to whatever from this day. It cannot be said that you should be regularized from 2 years back. On that, only one judgment, Millard. 2006, Volume 6, Supreme Court Cases 558. Though, Millard, this is a case of promotion, but the principles would apply subject to your lordship's correction. Millard, paragraphs 24 and 25. On a consideration of the submission made on behalf of the respective parties and the decision cited on their behalf, the consistent view appears to be one canvassed on behalf of the appellant. The decision cited by Mr. Rao has been rendered in the context of Rule 10 and other relevant rules which are also applicable to the facts of the instant case. Apart from the above, the law is well settled that initial appointment to a post without recourse to rules of recruitment is not an appointment to a service as contemplated under Rule 2, notwithstanding the fact that the appointee is called upon to perform duties of a post borne on the cadre of such service. In fact, Rule 39 of the general rules indicate that a person temporarily promoted in terms of Rule 39A is required to be replaced as soon as possible by a member of service who is entitled to promotion under the rules. It stands to reason that a person who is appointed temporarily to discharge the functions in a particular post without recourse to the recruitment rules cannot be said to be in service till such time his appointment is regularized. It therefore follows that it is only from the date on which his services are regularized that such appointee can count his seniority in the cadre. In the instant case, the authorities on the strength of several government orders giving retrospective effect to the regularization of the promotees have taken the date of initial appointment of such promotees as the starting point of their seniority. In our view, such a course of action was erroneous and contrary to the well-established principles relating to determination of seniority. In our view, the High Court took an erroneous view in the matter in applying Rule 4 and holding that the period during which the promotees had initially discharged the duties of district registrar, though appointed temporarily under Rule 10, was to be counted for determining their seniority. The decision of this court in L. Chandra Kishore Singh, relied upon by Mr. Sri Venkat Ramani, did not involve the question of persons appointed outside this service as a stopgap measure. The fact situation of the case is different. Well, my respectful submission is, Millard, though, Millard, this is on a case of promotion, then also, Millard, you absorb, regularize, Millard, these are, Millard, my alternative submissions. In case, Millard, your lordships are not with me in the previous issues, then also, Millard, regularization cannot be made from a back date.
Yes.
And when the last judgment is I cannot be worse off by approaching a court because the tribunal had given the benefits from a particular date. The honorable single judge had given it from a back date, more back than what the tribunal gave, number one. Number two, Millard, the honorable single judge has included the persons who have died, their families also, Millard, to get the benefit from a back date with arrears and all that. And one line, Millard, from a judgment, a recent judgment, 2025 SCC Online 290. Just one sentence from one paragraph. Paragraph 36. Finally, it is noteworthy that although the single bench directed further consideration of the claim of the respondent upon quashing the impugned order of rejection, the division bench went a step further and directed appointment. Power of an appellate court is circumscribed by laws unless a particular case in appeal is so exceptional in nature that the appellate court considers it imperative to exercise power akin to power conferred on appellate courts under Order 41, Rule 33. Such power should normally not be exercised. We have not found reference to the said provision as the source from which the division bench drew power to order appointment to be offered without respondent being subjected to the suitability test. Obviously, therefore, the appellants could not have been worse off for filing an appeal. Therefore, my lord, I respectfully submit, my lord, your lordships may kindly set aside, my lord, the order of the award of the tribunal and, my lord, the order of the judgment of the learned single judge. তুমি এলে বলেই তো তাড়াতাড়ি শেষ করে দেন, যাতে শুরু করতে পারো।
তুই তো কম্পাইলটা দিবি না, তো জুনিয়ররা বলেছে দেবো না, তোর কপিটা অন্তত দে।
এই একটা কম্পাইলেশন দিয়ে দেন।
So, my lord, what I'm on, my lord, I had a privilege to hear the argument of Advocate General, Foreign Advocate General. So, can you just one adjournment, my lord, so that I can prepare myself? I will go to the judgment. I'll have to go to the judgment, my lord. I can record this. I'll argue, my lord.
Mr. Banerjee, you can start.
My lord, there is some problem. In Bengali, it will not capture. When I start, I'll finish. So, at 3 o'clock, my lord, there is a single bench. They have finished their argument. So that chapter is closed. Now, in my turn, my lord, I want to start and finish on that day. I'm sorry to disturb your lordship. What I think, my lord, is that
But
then let it remain with you.
I have already marked it.
Let it remain.
So, my lord, one copy to be given to me, my lord.
All right, we do one thing. We keep one compilation.
No, I'll just serve.
কবে দেবে বাবা? জুনিয়র বলছে দেবে না, ওর কাছে কপি নেই।
It won't be a problem.
একদিন দিসনি কেন? না আমি আগের দিনও বলেছি, আগের দিনও বলেছি।
হ্যাঁ তাহলে এটা থাকুক, ওইটা তাহলে
হ্যাঁ জাজ সাহেবের থেকে পেয়েছি, না ছাড়ি কখনো। নট মার্ক মাই লর্ড, নট মার্ক, ইটস নট মার্ক।
আই হোপ নট। এই অন্যগুলো কিন্তু দেখাইনি। হ্যাঁ,
অন্যগুলো আমি দেখবো না।
না না, তুমি দেখাও, তুমি মিসলেড হয়ে যাবে।
না না, আর এই বয়সে মিসলেট হবো না, তাহলে বিপদে চলে যাবো।
ইয়েস
May I leave, my lord? I'm really sorry, my lord.
7, I am for the appellant, my lord. Would it be your lordship's pleasure to have it any day in the next week, my lord? Tuesday or Wednesday, I am led by Mr. Oyon Bhattacharya. He happens to be the arguing counsel, my lord. He's in some
have you completed service?
Service, my lord. I am not in.
Let us check up whether it is defect free or not.
I'm deeply obliged.
You are not in this matter.
I'm not in this matter, my lord. I have been instructed, my lord, since Mr. Bhattacharya is in some difficulty.
Oyon Bhattacharya.
Mr. Oyon Bhattacharya, my lord.
Criminal.
I'm deeply obliged. I'm deeply obliged.
At a can to file. You have not filed any application in connection with this. You have to file an application, na? Who is your other side?
My lord, I am not instructing, my lord. I am not briefed. Kindly have sit on next Tuesday or Wednesday, my lord, subject to your lordship's convenience, my lord.
Tell him to do the needful in the meantime.
I am deeply obliged. I am deeply obliged.
21st, রেখে দাও। 21st.
Deeply obliged.
Yes, next.
My lord, I am for the respondents 1 and 2, State Bank of India.
Uh-huh.
I am for the respondents 1 and 2, State Bank of India.
Who is your other side?
Lordship, Lordship, in this matter, I am praying for not today only, Lordship.
Sir, why do you bring the matter? Why do you mention that?
Lordship,
why do you mention?
Lordship, it was returnable today, Lordship.
Why do you mention, sir?
Lordship, only not today, Lordship.
Returnable has been made since adjournment was paid.
Lordship, Mr. Vidut Kumar Haldar is appearing, Lordship. He is on his legs in court number 14, Lordship. Only not today, Lordship. We will.
21st, yes. Not today. Not today.
It is your lordship. Affidavit of service, Lord. That's all.
You setting outside. Private one. Setting outside is wrong. Why he has come? ছুড়ে শুনে নামাতে দাও।
Mr. Samanto, defective.
For what?
কি দিয়ে স্ট্যাম্প রিপোর্টারের রিপোর্টটা কোথায়? হ্যাঁ, respondent number 3 in the memo does not find place in the impugned order.
No, because the impugned order was the respondent number 3 has been added by an order of the court. Your lordship will see that it's there. Secretary Law Department by an order, he was brought on record.
দেখেন এটা
It was by an earlier order. নাকি এই অর্ডারে? It was an earlier order. সেটা বোধহয় annex করা হয়েছে?
annex করা আছে।
স্টেতে আছে না? Because
Respondent number 3 is Allah Rakha Mia.
No. Respondent number 3 would be the
এখন
yes, the appellant private respondent.
You are for whom? You are the
Appellant
private
private respondent.
Private respondent. Who is the writ petitioner?
I am for the
আচ্ছা, লেখো Mr. Samantal, an advocate appearing for the appellant submits that now he was placed in whose place?
No, here, my lord, the writ petitioner, private respondent over here, he was the writ petitioner who challenged the appointment of temporary MMR of the private respondent.
All right.
Now,
this law secretary came on
by an order passed by the court, my lord.
he
I'll
was
show that.
impleaded as
I'm telling you, lordship. Lordship gives me a minute, my lord.
1A.
It will be order is
হ্যাঁ ওটা লেখো ওই he was impleaded as respondent number 1.
the order, impugned order, my lord, I shall place, no?
So your writ petition was allowed?
Their writ petition was allowed.
Your
and
appointment was set to
cancelled.
Cancelled?
Yes.
Now order has been implemented?
No, not yet. I have filed it and I have given them notice also, everything done, my lord.
Free to take appropriate steps to fill up the post?
Yes.
Affidavits, it was hard on affidavits?
Hard on affidavits. But state did not file an affidavit, but they brought on record everything. They made submissions.
we submit a report, lordship.
They filed a report.
Oh, that is with us?
The report is part of this, my lord, pleading.
Sure. My lord, I'll just make one humble submission, but my lord, admittedly, it was a PIL. If your lordship sees the cause title of the writ petition, lordship kindly comes to page, my lord, 16 of this T.
You are still working?
No, he was never appointed. He was not appointed. He wanted my appointment to be cancelled.
So now after this, are you continuing?
No. But
your appointment has been cancelled.
Has been cancelled, which is the subject matter before your lordship.
So there is no scope of entering order. We'll hear out the appeal.
No, my lord. Your lordship can hear the matter here itself. Everything is there. My lord, because
let us understand, you were in service.
Yes.
Your appointment was cancelled.
Temporary MMR. Appointment cancelled by virtue of the order of the court. In the meantime, my lord, he went for Hajj. Therefore, no action could be taken. He had gone for Hajj.
Now, has he returned and joined?
He has returned.
Not been allowed to
This
join.
is not service. Actually, temporary MMR is a licensing.
Licensing, my lord.
Oh, Muslim marriage?
Yes, lord, MMR.
MMR.
Therefore, my lord, what I was beseeching, my lord, first your lordship comes to page 16. It's a public interest litigation which was filed. It could not have been taken up by a learned single bench. The first point.
So why didn't you raise that point?
It will not confer jurisdiction. If a mistake is done, your lordship knows very well the law.
Typographical error, Mr.
No, it cannot be, my lord. This is the first point. Then, my lord, I'll come to the other points. it is implemented. They are there to implement. So let them not implement the order.
Not implementation, you are not being allowed to, you will not be able to function as a license.
That's right, my
Not implementation.
Yes. No, that's right, my lord. Kindly take it up tomorrow, my lord. I'll take only 5 minutes of your lordship's time. 5 minutes, not more.
Come on, next Wednesday. It has been pointed out
May I have your lordship's kind?
Yes.
Yes, my lord. May I have your lordship's kind leave to mention one assigned matter, my lord, which was assigned to your lordship. This is relating to the workmen of.
The numbered, it will be released. I shall release it.
Very well, my lord. Very well.
যেদিনকে থাকবে
Grateful, my lord.
give notice to your other side.
The notice has been given to the other side, my lord.
What is the matter about?
My lord, this is relating to an order challenging order passed in an application under 33(2)(b, my lord. My lord, the Statesman Limited, what has happened, my lord, the Statesman Limited had terminated certain employees, my lord, 5 of them. And for the sanction, my lord, it has to be gone to the Industrial Tribunal for the approval of the termination. The Industrial Tribunal, my lord, dismissed the application, stating it to be not maintainable, my lord.
All right. Please keep when I will sit next, you place it, please. To be mentioned উপরে দিয়ে। না না একটা ফার্স্ট কল দিয়ে দাও।
2, 3, 4. Lordship, item number 4.
I'm coming back.
6, 7, 8, 9, 10.
My lord, on behalf of
Yeah, we are coming back. Yes.
11, 12, 13, 14,
14. Coming back.
17, 19, 20, 21, 24, 5, 26, 9, 30, 31, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 3, 4, 5, 7, 8, 9, 1,
থেকে পাঠিয়েছে ও এগুলো সব জমা করে রয়েছে।
My lord, item number 32 and 33. First time appearing, my lord. First time appearing.
Please take your seat now. I'm coming to that matter. Please take your seat. Yes, Takun.
Item number 1.
They filed the no one appears. এইগুলো তো আগের দিন দেখা হয়েছিল। No one appears on behalf of the same on. Next.
Item number 3.
Same order.
Your Lordship, I appear on behalf of the petitioner. Your Lordship, I appear on behalf of DCB Bank Limited. The loan has been sold to ARC, ARCIL, Asset Reconstruction Company India Limited, Your Lordship, making the application infructuous. Your Lordship, I'd like to withdraw. I have the instructions.
You are on record?
Yes, Your Lordship. On Ashok Kumar, I'm a junior of Mr. Ashok Kumar Singh, Your Lordship.
The learned advocate.
Grateful, Your Lordship.
Same order. Dismissed for default order. Same.
Seven I'm heard the my lord KMC alleged contempt.
Complied.
My lord, this is old, madam. I have no instruction, my lord, and no contempt copy.
Oh, there was we didn't no order for service was there.
Yes, my lord, no
Then,
copy.
madam, you cannot appear, na?
According to instruction of the KMC authority, so I am appeared. Mrs. Tonusri Dasgupta appear. He also instruct me.
Contempt application has not
Application not served, my lord.
So
That's why.
Can I record you on?
Yes, my lord.
Dismiss for default. Yes,
Yeah, ঠিক আছে।
next. Sorry, we cannot do so. Petitioner seek to declare dismiss for default.
On behalf of Mohammed Kalam, I am paying only not today.
Not today. Same. Same.
14,
For the petition applicant, my lord. My lord, I have informed the applicant to collect the new incumbent, my lord. He failed, my lord. Nothing remains in this applicant, my lord. As your lordship, my lord.
Will you withdraw?
My lord.
The learned advocate appearing for the petitioner prays for
Good.
He's not coming. Client is not coming. Same. 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 Same.
21,
Same. Same.
23,
Same.
24,
Same.
25,
25, my lord. Probably, my lord, there was no order for, my lord, service subject to correction, my lord. I'm for the
No.
contemner, my lord. Then, my lord.
This same. 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 32 for the first is petitioners হবে এটা petitioners
I am appearing for the petitioner. First time appearing, my lord.
not today দেখে যাও পর এগুলো পরের গুলি সব নতুন এসছে
33 same, my lord.
Same.
34, my lord. Mr. Ujjal Rai is appearing on behalf of the petitioner, my lord.
Anything remains in the matter?
Yes, my lord. I was praying for a Passover, my lord.
Not today.
Great.
35,
দেখে দাও
36,
ডেকে নট টুডে করে দাও কে ডেকে দাও
37, 38,
সবই তো নতুন এসছে
38, 40, 41, 40, 43, 44, 45, 46, 47, 48.
Well, 48, my lord, I am appearing for the petitioner applicant, my lord. Though I am appearing before your lordship upon instruction, my lord.
Yes. What do you?
Yes, my lord. The purpose has been served, my lord. So, if your lordship may dispose of it.
Acha, you are the petitioner, na?
Yes,
the
madam.
learned advocate appearing for the petitioner that the present application has become infructuous. Order complied.
Yes.
So we can record that.
Yes.
দেখি তাহলে একটু ফাইলটা দাও আইটেম নাম্বার 48
Yes, my lord. I know.
দেখি একটু
একটু দেখি
the learned advocate appearing for the proceed with the to proceed with the inclined to proceed with the application. Okay. Yes. 49 not today. Yes.
50 not today, my lord. 50 not today.
Achha.
Not today.
Not today.
Actually.
Same.
5, 6, 7, 9,
61, my lord, I am appearing for petition.
Not today.
First time appear.
All right.
62, my lord. 63. 63.
Not today.
First
Not
time.
today.
4, 5, 7, 8.
Malat, may I, Malat, just Malat, disturb your lordship, Malat? Just Malat, I have prepared one thing. Just your lordship, at a glance, if your lordship see, then I will modify and Malat hand over your lordship so that I can assist your lordship.
Yes.
নামটা দেবো
Only Malat, serial number.
Supreme Court reference, what does it mean?
Malat, first serial number 1, my lord. Malat, serial number 1 means Malat, this particular appellant,
board appeal, your appeal.
particular appellant went to the Supreme Court. Your lordship similarly will find 38, 39, 42 and 44 serial number.
The writ petitioner went or the
No,
appellant?
no, appellant.
Board went. Board went.
Board along with Malat serial number 38, 39, 42 and 44.
Achha.
This appellant also went to the Supreme Court.
They did not file leave to appeal here.
Here also, because everybody, Malat, I just tell you, Malat, everybody, Malat, other than board, all appellant file leave to appeal because none of them were party
before a coordinate bench.
Before a coordinate bench.
Then
Malat, initially, Malat, when the order was passed, impugned order, Malat, immediately thereafter, only 5 appeal was filed, including the board. 5 appeal. One is by the board, and another 4 appeal.
Leave to appeal.
Leave to appeal. Filed. Malat, the interim order passed by the division bench initially, Justice Talukdar.
Modified the single bench order.
Modified the single bench order. Malat, that date, only 5 appeals were there. Only 5.
Then what happened?
Then all these 5 went to the SLP. All 5.
So you mean to say board and 4 others?
4 others. All.
Now board filed regular appeal and 4 others filed leave to appeal.
Leave to appeal. And in the Malat.
Yeah. So these 5 matters were taken up together. No.
In the Supreme Court?
No. This board.
Yes. In the 19th, Malat, the interim order passed by Justice Talukdar.
That is, do you remember the date?
19th May 2023.
Yes, then
Malat, the Supreme Court, Malat, we all went to the Supreme Court.
Against 19th May order. Achha, you went to Supreme Court.
19th May order.
And Supreme Court set aside, stayed the second part also.
Second part of the 19th May order. And Malat remanded back before this, Malat.
That was, what was the date?
Malat, this date of the order, your lordship.
August.
Malat, yes. Malat, 11th August 2023.
Achha.
Malat, this, your lordship, this type of order, the other day, Malat, also Malat Supreme Court passed because Malat, all the Malat SLP were not filed on the Malat same day.
Then how the others, the remaining all filed leave to appeal? After your leave to appeal and board appeal.
And Malat,
Supreme Court.
Just little facts, Malat. Malat, there are many people, like 32,000, went to the Supreme Court. filing SLP, leave to SLP. That those SLP were disposed of. I will file all the the order before your lordship. There, suppose you're in the one SLP, your lordship.
So some
1,000 candidate file SLP. Just 1 minute. 1,000 candidate file SLP. The another date, that SLP was disposed of in terms of the order of the 11th August. And then they remanded back to the before this division bench. Then they jointly did not file the appeal.
Separately.
They divided. After
they one particular class did not file leave to appeal here.
Yes, absolutely right, your lordship.
They directly went to Supreme Court.
Directly went to Supreme Court.
So when was those appeals order passed? Different dates.
Different dates.
Then what about the other matters? They file leave to appeal before this.
All leave to appeal, and most of the leave to appeal was allowed. Most of the leave to appeal allowed.
So those were passed on different dates, na?
Different. All leave to appeal allowed by coordinate bench. The Honorable Justice.
But some persons were there who challenged the order, who filed leave to appeal before the Supreme Court, apart from the 4 others who went with
absolutely, my lord. Your lordship is, my lord, absolutely.
Okay, can that number be given?
SLP number?
No. How many board and 4 others went to Supreme Court? Board's appeal and 4 leave to appeal. All those were disposed of then for final hearing. Remaining persons, you said some preferred SLP, again leave to appeal directly. What was that number, and what was the remaining persons who got leave to appeal from here? Because there are 44 appeals.
44. I have given chart, your lordship, 44 chart. 44 appeals. 44. I have individually, I have gone through each and every appeal, and all the applications. My lord, the difficulty is that, suppose a SLP was filed by thousands of candidates, but when they came to before this honorable court, they are divided. So therefore, that is why, it is very difficult to trace out,
All right. Thank you.
Though I am trying, my lord. I will, my lord.
Thank you. This will.
I will correct it, and I will hand over I will try to modify it, my lord, so that I can, my lord. Your lordship, keep it with your lordship. My lord, I have the copy.
You have a copy?
Yes. I have the copy.
Order sheeted yetar bhetor.
It with the client, my lord, as to, and I don't have instructions to that extent.
Not today kore dao. Recall kore dao order.
Item number 27. I'm extremely grateful and apologetic, my lord.
7 টা বলে দাও। কে নি তুমি নিয়েছিলে? তাহলে রিকল করে দিয়ে not today করে দিও।
Grateful, my lord. Deepest apologies, my lord.